So welcome everyone to our webinar today hosted by Elder Abuse Prevention Ontario. Today we're pleased to have a presentation on powers of attorney, advanced directions for care and financial decisions. Who decides and whose decisions are made, or how decisions are made, sorry. We are pleased to have Melanie DeWitt with us today, who's our guest speaker. If those who have attended in the past, we have had previous power of attorney workshops, and we always have ongoing requests for this kind of information. So Melanie's going to give her perspective based on her background and knowledge and expertise in the healthcare system and her work at Unity Healthcare as well. So before we get started, I want to provide our land acknowledgement. So today we are gathered on the traditional territory of a number of First Nations and acknowledge their stewardship throughout this land, throughout the ages. We seek a new relationship with the original peoples of this land, one that is based in honor and deep respect. Just a few housekeeping items before we get started. We do encourage everyone to make comments during the session in the chat box. Sometimes we see colleagues that you might want to communicate with, or post a comment based on what the presenter has been speaking, or share information. If you have a specific question for the speaker, please put that in the question box so we can make sure that we don't miss your question. We will be taking up those questions at the end of the session today. And as everyone knows, you will be muted during the presentation just because we have a number of individuals attending, so it's a little difficult to unmute everybody to make sure that we don't have any background noises. We will be recording, as I mentioned, the session. It will be posted on our website in a couple days, a little bit sooner if we're able to. It will be posted along with the PowerPoint presentation and any resources that are shared today, either through the chat box or through Melanie's presentation. We also will be asking if you wouldn't mind taking 5 minutes to do a short evaluation question. There'll be a link that pops up after the webinar, as well as a survey link in an email that you'll receive with the link to the recording as well. Just lastly, we do respect everyone's privacy and confidentiality. We understand that some people may be having experiences of issues dealing with powers of attorney. We are more than welcome to have those conversations if you have a case or a situation that you'd like to talk to us offline about. If you can keep your questions more general, because this is a public forum and we do appreciate that. So names are visible to other individuals that are joining us today, unless you put the word as anonymous. However, we do want to have those specific questions about scenarios or situations discussed sort of individually. If you can keep things on a general sense that has a question, then we'd be able to better respond to that in a better way through our presenter and through the Q&A box. We will try our best to do things, respond online as well as the end of the presentation as well. Just quickly, for those who haven't been to our sessions in the past, Elder Abuse Prevention Ontario hosts many webinars and conferences. But we do this because our mission is really to make sure that seniors are well informed, they have a voice, and feel safe and respected in the communities that they reside in. Elder Abuse Prevention Ontario has been mandated to implement Ontario's strategy to combat elder abuse. We've been doing this since 2003, and we are funded through the Ministry for the Seniors and Accessibility to implement this strategy. And the strategy has 3 main pillars: education and awareness, such as the event that we're hosting today. We do training for all frontline staff and various sectors, And we work with our community partners to increase the response and services for seniors and families who may be encountering situations of abuse or vulnerability. So it gives me great pleasure now to introduce our speaker for today, Melanie DeWitt. She's the Chief Legal Officer at Unity Health. And Melanie has been working as a lawyer on behalf of hospitals and healthcare for over 15 years as the Chief Legal Officer at Unity Health Toronto. As you can see here from her background, she's received her Juris Doctor at University of Toronto, and she also has her master's degree in public health at Johns Hopkins University. And she's very passionate about the work that she does. Just in speaking with her about preparing for this session, I know that she's got a wealth of information to share with you today. Lots of examples that she's going to share based on her experience working with healthcare providers, as well as older adults and families in the healthcare sector dealing with powers of attorney, both for personal care and for property. So without further ado, I'm going to stop my screen and allow Melanie to make her presentation. Thank you.
Well, thank you so much for having me. I see that we have people joining from all corners of the province and even outside the province and outside Canada. So welcome to everybody. I grew up in Sudbury, Ontario. So special shout out to the people who are joining from Northern Ontario. I'm now in Toronto, where I've been working as a hospital lawyer for the last 15 years. And really the impetus for this talk is that I will routinely get consulted on cases involving challenges that come about when a patient is not able to make decisions for themselves. And there are challenges that arise with the substitute decision making for that patient. So, there's so many different examples, but, substitute decision makers who are estranged from the patient, but find out that they have this role to play in the absence of a power of attorney. Substitute decision makers, often children who are equally ranking, again, because there's no POA singling anyone out, who disagree and who are really distressed about what decisions to make for a parent. Maybe they don't know what the parent would want, or they disagree about what the parent would want. And then from time to time, cases come forward around a concern that a substitute decision maker isn't making decisions in a patient's best interest, or isn't making decisions in accordance with the patient's known wishes. Often those wishes are, verbal wishes that everybody's heard around the dinner table for years and years, but they're not captured in a power of attorney document. So there's a debate about, what the wishes are and whether they're applicable. And on the managing property side of things, often I'll get consulted because there are challenges in discharging a patient from hospital because no one's managing the finances. So the question of, the patient's incapable, who's going to sign the lease? Who's going to sell the house to free up finances? And that can keep a patient in hospital much longer than they otherwise would stay. So all of these experiences have created the lawyer you have in front of you, who is a big, big fan of powers of attorney, because they really empower people to choose who will make the decision when they're not able to, and to give instructions about how those decisions will be made. So that's really empowering from a personal perspective, but it also goes a long way to making things easier on family and friends when those situations arise. So that's really why I'm here today, and I go around speaking about powers of attorney. More than happy to take questions as we go, so please drop them in the chat or in the Q&A. And so let's get started. We're going to go over both powers of attorney for property and powers of attorney for personal care. So just starting off with, what is a power of attorney? Or sometimes we hear POA. What is a POA? So two types of powers of attorney. We're going to talk about each of them. One is what is called in Ontario, but in every province, you'll see something either the same or similar, a continuing power of attorney for property. Okay, so that is the power of attorney that has to do with finances and property. And then the second one is a power of attorney for personal care. That's going to govern treatment decisions, decisions about admission to long-term care, and personal services. Sometimes people will say, well, I have a will. How is this different than a will? Doesn't my will cover this? So a will help to decide what happens to your property after you die, after your death. A power of attorney is going to be enforced when you're alive, but you can't make decisions for yourself. Okay, so both are legally binding documents, but the will only kicks in after death, and the power of attorney is only valid when you're alive. Couple important definitions just to get us started off. So when we talk about an attorney in this context, we're talking about the person who you authorize to make decisions for you in a power of attorney document. And that is also known as a substitute decision maker, or sometimes we shorten it to SDM. So attorney, POA, substitute decision maker, SDM, all referring to the person who's making decisions for you if you're not capable. And you, in designating this individual, is referred to as the grantor, so the person who creates and signs the power of attorney. Okay, so let's just do a bit of a deep dive in the power of attorney for personal care, putting aside property and finances for now. So what's a POA for personal care? It's absolutely a legally binding document, and it really performs two functions. It names who will make care decisions for you if you're not able. And two, it can provide instructions on how that individual or how those individuals should be making those care decisions. So who can write a POA for personal care? You may be thinking, oh, do I need one of these? Am I allowed to write one of these? So really just two criteria. One, you have to be at least 16 years old to create a power of attorney for yourself. And two, you have to have the necessary mental capacity. So what do we mean by capacity to write a POA? It means that someone is able to understand that the person that they're going to appoint genuinely cares about them, so that they're able to identify the people in their environment who genuinely care about them, and understand that by naming them, they may have to make decisions for you if you're not able to do so. So it's a pretty low threshold for capacity to write a POA. You could be incapable of making a treatment decision, which often requires a higher level of capacity, but still retain the capacity to write a POA. So that's important to remember. So when we say you have to have capacity to write a POA, you might be saying, well, who's going to decide if I have capacity? And really, it's the person who is writing or assisting you to draft the POA. So if you've gone to see a lawyer to assist you, then they're assessing your capacity. They may not be doing it formally, but they may just by virtue of, questions and answers get a sense that, oh, this is someone who's capable to write a POA, no problem. And that is going to be really good evidence, right? If your POA is ever challenged down the road, the fact that you had a lawyer assess your capacity, and this is someone who is familiar with how these assessments are made, and the lawyer will say, yes, the person had capacity when they wrote the POA. But if you're doing it yourself, which is absolutely possible to write up your own POA, then you're kind of assessing your own capacity. All right, so we've gone over who's writing the POA, but who can you appoint as an attorney for personal care or an SDM? Who can you name in the POA document who will make decisions for you if you're not capable of making a treatment decision? So again here, two main rules. One is the person you name has to be at least 16 years old. And it cannot be someone who you pay to provide you with health services. So they can't both be someone who's paid to provide you with health services and someone who's making those healthcare decisions. And we can think about, and maybe this is good to drop in the chat, what other traits would it be good for a POA to have? So what are some of the other characteristics that we would look for in designating someone as our POA? Anyone have any ideas about that? Yeah, right. Someone who's dependable, someone who's available, right? We might have a really close relationship with someone, but they have 4 young kids and they work and they live overseas. So that may not be the right fit in terms of their availability. Someone younger, someone who's honest. Good. So these are all things you want to turn your mind to. What kind of traits do I want in the person who's going to be making decisions? Great. Leanne, great one. Someone who understands your wishes, right? And someone who you think will respect your wishes, even if they don't agree. Often we're looking to our adult children to do this. And trying to educate them about what are our wishes, our values, our beliefs that they're going to want to draw on when they're making decisions. So that's all very good. There's a question in here about what's the difference between a POA and an executor. Great question. That goes back to the slide about POAs and a will. So an executor is a term that we use in relation to wills. So the person that we appoint to deal with our estate after death, that's the executor. And a power of attorney is who we name in a power of attorney document who will be making decisions on our behalf when we're still alive but not capable. All right, can I have more than one person? Can I name more than just one person to make decisions for me in a POA? Absolutely. So one permutation of this is that you can appoint more than one person to act as your attorney. You can say these 2 people are to decide jointly, or you can say, just go to the first person that you're able to contact. You just need one of them to consent. So you can name 2 people and they can have the authority to decide either jointly or separately. You can also name backups. So if Mary is not available to be my POA, or if she resigns, then I would like David to step into the role. So you can also have backups. When does a POA for personal care take effect? So this is important to understand because it's a document that you ideally prepare when you're well, way before you need it. And it only starts, it's only triggered when you lose the capacity to make decisions with respect to your care. So it's for medical treatment, long-term care, and all of those personal support services, but not until you lose the ability to make those decisions on your own. So what does that mean, right? We talked about the capacity to grant a POA, to write one, which was about understanding that someone would make decisions for you and knowing that they're going to make decisions in your best interest. What does it mean that I don't have the capacity to make care decisions? Because we talked about how the thresholds were different. So anytime someone is proposing a treatment to you or proposing an admission to long-term care, they have a responsibility to ensure that you have capacity. And sometimes you'll know that there's actually a formal capacity assessment happening, but sometimes it's just through conversation that someone gets reassured that, yes, I'm dealing with someone who has capacity. capacity to make treatment decisions, to make long-term care decisions, is a two-part test. No matter what treatment decision, this same two-part test applies. So one, you have to be able to understand the information that's relevant to making the decision. So just a basic ability to understand the information relevant to the treatment decision. And two, you have to appreciate the consequences of saying yes or no to that treatment. So most people will fail the second part of that test. They can still understand the information, but they can't apply the information to themselves. They don't appreciate the consequences of saying yes or no. So let's just take an example. Let's say, I am 90 years old. I live at home. I'm very independent. I have a fall. I fracture my hip. I end up in hospital. And the doctor is saying, I really think you need to have surgery. We'd like to take you to the operating room for surgery. And they go through all of the information that's relevant to surgery, and I understand it. I'm following along. And at the end, I say, you know what? I don't want to have surgery. Just send me home. I think I'll be fine. I'm sure I can still walk the stairs. I can still make meals. I'm not in any pain. That starts to suggest that you don't appreciate the consequences of saying no, because you don't appreciate what your home situation will be if you go home without surgery. Versus a situation where I say, thanks, I don't want the surgery. I really value my independence. I don't want to have a long hospital admission and have a long rehab stay. I get that I'm going to have to manage my pain and I'll probably be confined to a wheelchair, but I'm going to set up some home care services, and I have kids who can help me with meals, and I would prefer to go home. So that is a decision that maybe the doctor wishes his own mom wouldn't make, but it's a capable refusal, right? You can tell that I appreciate the consequences of what it means to go home without surgery, and I'm accepting those consequences, even if others might disagree with me. It's my wishes, values, and beliefs that are driving the decision. So in a situation where you don't understand or appreciate, you fail one of those two branches of the test, then the physician's going to be looking around for a substitute decision maker. Okay. And that person is going to make a decision on your behalf. So, and we're going to look at who will be that substitute decision maker. Now, let's say you're not capable of making a treatment decision and you don't have a POA. Often the question I get asked is it too late? So often it's not too late, right? Because you can be incapable of making a decision about whether you're going to have surgery, but still be capable to make a POA for personal care. Because you can still look around you and say, yes, I would like to appoint my daughter. I understand she's going to make decisions for me and she's going to do that in my best interest. So you could be incapable of making a treatment decision, but still have some time to create a POA. And otherwise, if you don't have a POA and you don't want to create a POA, or you don't have the capacity to make a POA, then a substitute decision maker gets appointed for you. And here's how that happens. So this is the hierarchy of substitute decision makers that you find in Ontario in the Healthcare Consent Act. And the treatment provider is always looking for the highest ranking individual in this list. Okay. And you can see that number 2 is your POA, is the attorney for personal care. So we appoint POAs, we draft POAs because it means that the highest ranking person on the hierarchy will be your POA. we won't have to go into the blue section and just pick the highest ranking person from this list. You get to choose. So the red section is, you know, people who are chosen either by you or by a court. So attorney for personal care is almost always going to be the highest ranking SDM, unless there's a guardian appointed by the court, which is quite rare. And so, you know, that's how you're guaranteeing that it's someone who you choose that will be making decisions. But let's say you don't have a POA, there's no court appointed guardian. Then you're going down into the blue section and you're not choosing. We as in the hospital, that your care providers have to just choose who's the highest person on this list. So we start with a spouse. So that can be either a common law spouse or a partner. They're quite broadly defined in Ontario. Then if you don't have a spouse or partner, then it's a child over the age of 16. And here it's important to note that if you have more than one child, equally ranking people on this list have to make decisions together. So we're not just looking for any child, we're looking for all of the children who then become equally ranking substitute decision makers. And then you've got parent with custody rights, parent with access rights only. We're then going to a sibling. So brothers or sisters can be by blood or by marriage or by adoption. Again, once we locate them, it's not just one, it's all of them are going to be equally ranking and are supposed to be making decisions together. And then number 8, a bit of a catch-all here. We're just looking for any other relative who's willing and available to step in, again, by blood, marriage, or adoption. And everybody ends up with an SDM because the substitute decision maker of last resort is going to be the public guardian and trustee of Ontario. So if your care team goes through this list and they can't find any relative at all, then they're going to go with the public guardian and trustee. And you may have a friend, a great friend at the bedside who clearly cares a lot for you and would make decisions in your best interest, but they're not on the list. And there's no POA. And so the guardian of last resort in that situation would be the public guardian and trustee. Okay, so hopefully that is clear and just helps to point out how naming someone in a POA puts them at number 2, and then we don't have to go through the rest of the list to identify the SDM. So I'm sure I'm missing some questions, but one of them here is, does the PGT do care decisions? Absolutely. So anytime there's a care and treatment decision or a decision around admission to long-term care, it's the public guardian and trustee that gets called, and they have people who are assigned who have caseloads, and that one of them would make a care decision on your behalf. Now, they don't know you, they've never met you, you know, they may have very limited information about what your wishes, values, beliefs are. They're making decisions on your behalf. Okay, what's the difference between number 1 and number 9? So number 1, a guardian appointed by the court. It is possible to go to court and ask the court to appoint a guardian for an individual. So often we do that with someone who we know is going to need this kind of support for their entire life. So you have a guardian appointed for the individual. It's really not very common. It's quite expensive and lengthy of a process to go through. So if you name a POA, you know, you're pretty guaranteed that no one is ever going to trump the attorney that you've named in your POA document. Do the adult children and parents all share equal decision-making power? Yes. So if there are children over the age of 16 and a parent involved, they're all going to be equally ranking substitute decision makers, as long as they're all willing to act in that role. If the spouse is legally defined as the POA, then the children are not going to have the same rights, or really I call it a responsibility, to make care decisions. So whoever you name in the POA is going to be making care decisions. Now, that doesn't mean that other people, like children, won't have, a really big role to play in terms of supporting, and that they won't be at, case conferences with the care team, or they won't be involved in shaping some of those decisions. But at the end of the day, the care team will look to the individual named in the POA to make a decision. PG&T is there for everybody, and they're not charging the patient or the hospital in this situation. It's a statutory function that they perform, that they must perform. So once a physician decides that you're not capable of making a treatment decision, and there's no one higher ranking on this list, then the public guardian and trustee automatically gets involved. They rely on the physician's determination of incapacity, and then they make treatment decisions from there. Great question, Noelle. So what if someone can't retain information? Could they still be capable? That's a really good question. Because the care team will always look to provide accommodations to a patient. So let's say they can't retain information, but if they have a written summary of things, they can still talk through a decision, then they're absolutely capable. So really important to bridge any distance that exists, and that you can bridge, and that can be, interpretation, translation services, and that can be just different modalities of presenting the information and working with the information. So someone can absolutely still be capable if they're not able to retain information. Those needs just need to be accommodated. All right, so let's keep going, but happy to keep taking questions. Someone points out it's important to keep in mind that decisions are treatment specific, 100%. So I always bring out this example. So you have to assess someone's capacity for each different type of treatment. And there's no age of consent and capacity in Ontario. So I always say, a 12-year-old can be absolutely perfectly capable of consenting to treat a rash on their leg, right? You have a rash, it's not going to go away without an antibiotic cream. You apply this cream twice a day. The risks are that it might get a little bit red. The benefits are that it's going to deal with the bacterial infection. Child understands the information, can appreciate the consequences of using or not using the cream. They're capable with respect to that decision. Same patient has to make a really complex decision around cancer treatment that involves surgery and chemotherapy and radiation and what order to put it all in. And so you would do a separate capacity assessment to see if they have the capacity to make that decision. And it may be that they have the capacity to make simpler decisions, but that they lack the capacity to make more complex decisions. So capacity is always specific to treatment. It's also specific to time. So sometimes we'll have patients who, if you catch them in the morning, they're clear, they're capable. And so we go to them to make treatment decisions in the morning while they're capable. Because if you try to have the same conversation at 5 o'clock at night, they've lost capacity. So where capacity is specific to time, it's also specific to treatment. All right. Someone's asking, can anybody report a concern to the public guardian and trustee? So yes, the public guardian and trustee has a role to play to safeguard individuals against financial abuse or care decisions not being properly made, so they can be engaged. Okay. So we've talked about what are the criteria for you to write a POA. We've talked about who can be named in the POA to make decisions and when that's going to kick in, when you no longer have the capacity to make a treatment decision. So the next big piece to tackle is, what about your wishes? So it's not just about who you name, but what about directing people about how to make decisions on your behalf? And here it's important, and people don't always recognize this when they're named as a substitute decision maker. They see it as a power, but really it's a responsibility. And first and foremost, it's a responsibility to make decisions in accordance with someone's wishes, values, and beliefs. So there is a legal obligation. It's not just a should, it's a you must make decisions in accordance with someone's expressed wishes, values, and beliefs. And that may be things that you just said out loud at the dinner table. You know, every time a conversation about mechanical ventilation came up, every time the issue of do not resuscitate came up, you always just had really clear wishes about that, right? You said things like, I would want everything to be done, right? I would want God to decide. Or you may have said, you know, I wouldn't want to live like that. I wouldn't want to be around if I couldn't recognize my children. And so those are all things that have, you know, you say out loud over time. They don't need to be anywhere specific to be binding. It could be things that you wrote down, though. It could be something you wrote in an email. All of that is binding on the SDM. They don't have to be articulated in writing in your power of attorney documents, but obviously it's going to be much more clear and provide much better direction if in writing you reduced your wishes, values, and beliefs when they, you know, really influence the way you'd like care to be directed in a specific situation. So I really encourage people to create POAs, but to also create POAs that provide specific direction about how you would want care decisions to be made when, you know, when it's something that matters to you. Sarah's asking, can the same person be an executor in a POA? Yes, absolutely. Okay, so how does an SDM make decisions? How must they make decisions? Again, it's not a right, it's a responsibility. So the wishes that you express before you lose capacity are binding on the SDM. And if the care team knows about those wishes, then they're going to coach the SDM that those wishes are binding on them. If there are no specific wishes that are applicable to the decision at hand, then it's still the case that your values, your general wishes, and your beliefs are still relevant. You know, so what do we know about mom? Is she fiercely independent, or would she love to live in a group setting? You know, are there any religious beliefs that really influence what kind of care decisions she would want to make? So still, those general values, wishes, beliefs still influence the care decision. And then otherwise, aside from the patient's own values, wishes, and beliefs, then there's a best interest test. And it's a 6-part test that's outlined in the Healthcare Consent Act. And it talks about, you know, with the treatment, is the person's suffering going to be alleviated, stay the same, or get worse? Do the benefits outweigh the risks? Are there any less intrusive ways to confer the same benefit? So a 6-part test that's fairly objective, that's supposed to guide the SDM towards making a decision in your best interests. So how does an SDM make decisions? Number one, your values, wishes, and beliefs. The more specific they are, the more applicable they are to the care decision, then, you know, the more you're going from A to B rather quickly because it's truly binding. And then 2, aside from those values, wishes, and beliefs, what in the patient's best interest. That is how an SDM has to decide. But people don't go to school to become an SDM. You know, often it's a phone call one day that says, you're the highest ranking individual on this list. You're going to make decisions. So I think there's variability in how this is actually implemented on the front lines. Okay, so putting it all together and just taking an example and letting us talk through some of the challenges here. So going back to Miss Smith, who's our 90-year-old and broke her hip at home. She fell while walking to the washroom. Physicians recommending surgery. Miss Smith doesn't want surgery. She doesn't want to stay in hospital. She worries about rehab. She wants to go home in a wheelchair with help from her kids to eat and bathe. So when someone in that situation says no to surgery, the first question the physician is going to ask is this a capable refusal, or is this an incapable patient? And, I think there's a lot of moral distress that kicks in on the part of healthcare providers because they want to heal, right? They want to fix it. They want to heal it. They want to give what they think is the highest quality of life. So a refusal in that situation really gets them thinking and kind of gets them thinking along the path of incapacity. But as we talked about, you could have a capable refusal that's at odds maybe with what I would want my mother to do, but it's a capable refusal that we have to respect. And here I think the role of ageism really comes into play, unfortunately. So sometimes when we see someone who's elderly, who feels to us like fragile and vulnerable and someone we would want to protect, and the kind of way that we know how to protect is to give them what we think is the best possible care. So often the conversations that I'm having or my ethics team is having with care providers is like really trying to tease out, is this a capable refusal? Just because they're old, it doesn't mean they're incapable. Or are we really dealing with someone who's incapable because they don't appreciate what will happen if they go home without surgery? And so again, that test for capacity to make a treatment decision, does Miss Smith understand the information? Does she appreciate the consequences of giving or refusing consent? And so let's say that the team does this work, they really try to tease it out, and for whatever reasons they decide, okay, no, she's not capable of consenting to surgery. She thinks that she's going to be pain-free and doing stairs, and that's just not consistent with what we can achieve without surgery. She's not able to put herself in the circumstances that she's living in right now. We need to find an FDM. And so we find out that Miss Smith is unmarried. But she has 3 kids. Great. So the 3 kids are going to be the highest ranking people who are going to be the SDMs, unless she has a POA. Does she have a POA? No POA. Okay. So all 3 children are the SDMs. So we call all the kids in to come and have a case conference with the care team on Friday because we want to talk about how we're recommending surgery. And 2 of the kids say, yes, mom should have surgery. And 1 says, no, she shouldn't have surgery. She's always said really clearly that she does not want to have surgery unless it's needed to save her life. She's refused. Remember, she refused surgery 10 years ago for that thing. She would just want to be home, and she would want to be in a wheelchair and having us around making meals. And so now we have a family who's really distressed because they don't know what mom would want. And we've got kind of this 2 against 1 situation. So you can imagine the turmoil that the absence of a POA or an absence of, understanding what her wishes are can do in a situation like this. Or, it's like a choose your own adventure here. Or let's say she's found incapable of consenting to surgery. She's unmarried. She has 3 kids. She has a POA. It names one of those 3 children, and it makes clear, because she's turned her mind to this, that she would like to avoid surgeries, and she would rather focus on preserving her time and her quality of life at home with home care around her kids. She's fine with Meals on Wheels. Now you've got, a much simpler situation. You get to, you get to the outcome quicker, so you get home more quickly with much less family strife. So I see these situations play out like all the time, and I'm really a proponent for for having those power of attorney documents, and for them to spell out values, wishes, and beliefs for our loved ones, so that it's simple for them in what is otherwise already a challenging situation. Okay, so who should do a POA? I would say anyone, everyone. But certainly, you know, if there are wishes that you want to be clear about, if you want to appoint someone who otherwise wouldn't be the SDM, when you look at that hierarchy, you know, if you looked at the hierarchy and you went, oh, it would be them, I don't want it to be them, then you need a POA. And just to reduce uncertainty in the event that you can't communicate. How often do you have to do one? You know, you want to make sure that your POA reflects your current wishes, but it doesn't expire. So long as your most recent POA still reflects your wishes, then there's no need to update it. And, you know, how do I do a POA? So do you need a lawyer? No, you don't need a lawyer. But people will get a lawyer to help them, and to help them, you know, in case later on they think that they may need someone to attest to the fact that they were capable when they granted the POA. So, you know, there's private lawyers that you can call. The Advocate Center for the Elderly also offers some services. They're a great organization. Pro Bono Ontario, if you're fairly low income, they'll do one over the phone for you. And there are some legal clinics that can also help if you're on the lower income side. You can also do it on your own. So these hyperlink, and I will share my slides. So there's a POA kit that gets put out by the ministry. That kit is available online. And Clio does a great little kind of pathway to complete your own, which you can also use. All right, we spent quite a bit of time on the powers of attorney for personal care, which I think are really important, but I want to save some time here for powers of attorney for property. Big distinguishing feature is that a power of attorney for property can kick in when you're not capable, but it can also kick in when you are capable. Whereas a power of attorney for personal care is only when you become incapable. A power of attorney for property can be when you're incapable, but it can kick in earlier if you specify it. Really, with a power of attorney for property, you know, anything that you can do with your own finances, pretty much, someone else could do. In order to grant a POA for property, you have to be 18, and have the necessary mental capacity. The test for capacity is a little bit different. So it's a little bit higher of a threshold. You have to know what property you have, who depends on you, you know, where your assets exist. And again, you or the lawyer who does the POA for you will assess that capacity. What about capacity assessments? So often with a POA for property, we say, oh, we need a capacity assessor. And you do need one of those if the power of attorney document itself requires an assessment before it's triggered. Or if there's a guardianship application underway, then there will be an assessment required. These you do have to pay for the assessments. And it's often difficult and challenging and doesn't feel great to assess someone's capacity to manage their property when they're unwell. And so I think a POA, having it, you know, in existence at the front end helps to avoid a lot of that. Who can you appoint? Anyone who's over 18. Again, not someone that you're paying. You can have more than one attorney. You can have backups. All that is okay. Can start right away, or it can start when you become incapable. It's up to you and what you stipulate. What if you don't have a POA and you're incapable? Again, you may be incapable of doing a financial transaction, but still be capable of granting the power of attorney. If not, then someone can go to court to be appointed as your guardian of property. And in a situation where you don't have a POA and no one's gone to court, then you can be assessed so that the public guardian and trustee becomes your statutory guardian for property. All of these things take quite a bit of time. And often I see patients languishing in the hospital because their discharge arrangements depend on someone taking steps, like to sign a lease or to do some sort of financial transaction. And so having a POA document really helps guard against that. So who should complete a POA for property? I really encourage people to have these in place so that you're choosing who's going to be making decisions on your behalf. You're providing instructions. You're reducing the work, the expense, the uncertainty among family and friends, and just reducing the delays that sometimes transpire because we're waiting for a capacity assessment. We're waiting for the public guardian to get involved. We're waiting for a court-ordered guardian to be appointed. Going to court these days, the system is super backed up, just like everything else. So it can take months or over a year to have this happen otherwise. And again, the POA doesn't expire, so it should reflect your current wishes, but there's no expiry date. I'll stop there just so that we have, and I'll stop sharing, just so that we have some time to take questions. And you've got my email at the end and my phone number at the end, and I'm always happy to connect with anyone afterwards as well.
Thank you, Melanie. That was so informative and engaging. I think everyone really appreciated you answering some of those questions as you went along in the presentation as well. There was a few questions on capacity. I'm just going to try to pull them together. So question around, and I think you kind of alluded to it, but when people kind of come in and out of capacity and they, can they change their power of attorney or revoke it? If they remember and then the next day they don't remember, and what should someone do in that sort of situation? And I think it's really, and you did a good job of clarifying who makes capacity decisions, because it is different people for property and for care treatment. I think people get those mixed up very often because it is complicated. So, if it's a healthcare decision and the capacity is in and out, that will go back to a doctor.
Yeah, so then you'd be working with, let's say you want to revoke a power of attorney, you want to name someone else. So you want to revoke the one you have and you want to grant it to someone else, and you're in and out of capacity. There's like a gray area, but hopefully your care team will work with you to identify a time during the day when you're pretty reliably capable. And that may be a time when you want to use a lawyer if you have the ability to do that. Just so that there's someone who can attest to the fact that in the moment that this POA was revoked and granted, I had a capable individual in front of me. But so long as you have capacity, you can grant and revoke a POA. And obviously there's like a gray zone where people are losing and gaining capacity, or where things are in flux, but you're looking for a time when they meet that two-part test. Yeah.
And I find that sometimes people will go to their doctor and ask for a letter of opinion. Are those valid for both property and personal care? So they'll say, I have a letter from my doctor saying that, mom's not capable. But, as we know, capacity is very broad and it's not a global capacity. So
Exactly.
the letter of opinion, sometimes I question when people will tell me that they have that. And so I wonder what your take on is of that.
Yeah, so I think it's maybe of some value if they're saying this is an individual who is capable of granting a POA. That's going to have some weight to it. But because treatment capacity is really specific to the treatment, there's no such thing as being globally capable to make treatment decisions. It's not really how the law works. So, I mean, it may serve some purpose down the road, but it's really the individual who's proposing the treatment that's in the position and has the legal responsibility to say if the patient is capable or not. Can a staff member in long-term care be the POA for a resident? No. So that would be contraindicated because they're in the position of indirectly benefiting. They're being paid to provide care. So they would not be the SDM. What if someone disputes the POA's ability to make decisions and the decision is time sensitive? So if you're challenging like that, it's a valid POA, you have to go to court to do that. And so the care team is going to be in the position of having to decide, do they have a valid POA just on the face of the document? So often they'll send me the document and say, does this look like a valid POA? It was authored 2 years ago. We don't know about capacity 2 years ago, but does it have two signatures? Is it dated? All of those things. And then they'll decide whether to go with the person who's named in the POA pending that court process, or default to the highest ranking individual on the hierarchy of SDM.
And dealing with hospitals, so how does a hospital deal with a substitute decision maker or POA for personal care who's not making suitable decisions for a patient? And I know
Yeah,
there are avenues for hospitals to take, so maybe you can describe that.
great question. So in that situation, I will often start with like, is the SDM themselves capable? Because that's one of the prerequisites, is you have to have a capable decision maker. Whether it's the patient or the SDM, they still have to be capable. So sometimes the failure to make decisions in the best interest is actually a lack of capacity, in which case we just automatically go to the next highest ranking decision maker. But sometimes it's just someone who's not making decisions in the patient's best interest, in which case we, if time permits, we spend a lot of time coaching the SDM on what their responsibility is, what's the test for making decisions. And if they still persist in making decisions against a patient's best interest, then the remedy is that the physician has to bring an application to the Consent and Capacity Board, and the board will convene a hearing within 7 days, and they'll review whether the SDM is properly exercising the responsibility to make decisions in the patient's best interest, or if they should be replaced. And sometimes the family member will initiate that CCB hearing as well, because they'll say, I would like to be appointed as the representative, which was number 3 in that list. So doesn't go above the POA, but is a pretty high ranking position to assume. If a person doesn't want to be a POA, so one of the criteria, like the prerequisites for being an SDM, is you have to be capable. You also have to be available and willing. So if you're not capable, available, or willing, then the care team just moves to the next individual in the hierarchy.
And what if that's a property decision? So if it's looking after property, then
Yeah.
you can inform if the person's incapable, then they can't actually tell them they don't want to because the person can't understand and appreciate what they're saying. So what's the step there?
Yeah, so for property, if the attorney wasn't willing to act, then they would withdraw. They would resign from, and you have to do it in writing. There are some criteria for being able to resign. And then unfortunately, it's not like there's a hierarchy on the property side. So it would be either someone going to court to be appointed guardian for property, or an assessment being done and the public guardian and trustee getting involved on the patient's behalf. Yeah, property is tricky, and it's really sad because I often see it bogged down, like great discharge plans, but no one's able to sign on the dotted line.
And there's a question about disputes between POAs. If there's more than one POA, what if one POA is
Great
abusing
question.
their responsibilities, right?
Yeah, great question. So equally ranking decision makers, they have to agree. And if they disagree, it's actually the public guardian and trustee in Ontario who make the decision. So before we go to the PG&T, we would, in a hospital scenario, we would have like a family meeting with all the SDMs there, with the care team there, with the recommendation and ethics there, and really trying to talk through like what would the patient want in this situation. And you guys should kind of be on the same page when we look at the best interest test, when you look at the patient's wishes. And if not, if at the end of that process not, then we would go to the public guardian and trustee to make a decision.
No, that's great. And then there was just a question, I think, we get this often too, is in some of the presentations about access. So does the POA for personal care have access to limiting access to
Yeah.
a family member or a person coming to visit them, particularly in care settings, we find that happens?
Yeah. Not strictly speaking. So that the responsibility doesn't extend to saying who should be on or off site in a hospital or a retirement home, but often what underlies that request is a concern about safety and well-being. And so I think in that situation, as POA, your voice is going and your voice and your voice is making decisions in the patient's best interest is going to carry a lot of weight. And what that should trigger is kind of a meeting with the care team to discuss what the concerns are and what kinds of limits need to be imposed as a result of those concerns. So it's not the authority to limit, but it's going to be a powerful voice in just shaping what your loved one's housing situation and who's going to be in and out of the premises. Great question, Bella, about MOCA, because people equate MOCA scores with capacity all the time. You know, a MOCA score might tell you a little something about whether someone's capable or not, but the only test for capacity is, do you understand and appreciate? So the MOCA does not make you or capable or incapable, the score alone.
I'm just looking to see. I know we're just running out of time here. Can the other question is around if the power of attorney can get paid for their time or for travel, for either being for personal care or for property. And there is, I believe, in the act, they can ask for, I think there's a percentage in that.
Yeah, reasonable expenses. And I don't have off the tip of my tongue what that is, but it's not supposed to be like a paid gig. It's just should be more of your kind of your out-of-pocket expenses or the opportunity costs.
And people do
Right,
have to be financially accountable, right? So,
exactly.
keeping, the money separated as opposed to putting everything into your own account and that kind of thing.
Yeah, all of that can be very easily audited. Can someone name you as an SDM without letting you know? Yes, they can name you in a POA document. You know, obviously that's not best practice. You want to let people know, you want them to agree ahead of time, and you want to impart on them what your wishes are. But if they do, an SDM, it's a big responsibility and you don't have to take that on. So you have to be willing and available. And if you're not willing and available, then the care team would just go to the next highest ranking individual.
Great. Is there any other one? Like, I know we're running out of time and we just have a couple other just final slides. Is there any one thing you want to last say, Melanie, before what we can do is maybe go through a lot of the questions because they're both in the chat and the question box. So we're trying to navigate both sections right now. So what we can do is summarize them maybe and see if Melanie can just respond to some of those as well. Just also, we do have a conference coming up talking about reporting, and we are hoping to have a person from the PGT join us for that session as well, where some of these questions can be specifically posed to them, and specifically about some of this reporting and response rules and responsibilities when it comes to some of these discrepancies and understandings of capacity.
Yeah, great. I can keep going for those who have a few minutes. Seema asks, is there like a list of POAs anywhere? Does it get registered somewhere? No. So these are documents. You have to keep the document, and it's the most recent POA that will be valid. Unless it's a court-appointed guardian, there will be no record in the court system, and they're not kept anywhere else. Oh, big question from Betty Ann, who asks about MAID, so medically assisted dying. Can you outline wishes around MAID in a POA? So for now, there are no advance directives permitted for medically assisted dying. You have to be capable at the time of the medically assisted death. But I know that is constantly being reviewed by the federal government, so that may evolve over time.
Great. Thank you for all everybody's engagement and asking the questions. There have been some really good, insightful questions and ones that we haven't heard before. And Melanie did a great job navigating both your presentations and doing the questions at the same time. I think it was very informative and educational. And I know that I learned, every time we do these, we always learn something new in the presentation. So we'll sort of reconnect with Melanie after the session and post some of these into the website after the event, maybe in a document just to summarize some of those key points that have been coming up through the questions. Just so people know, we do have a few more webinars coming up this month and next month. So we have one coming up on mental health, and this one will also be an engaging webinar. We're having a theatrical kind of play that will be done online, and it is with the Two-Sided Mirror organization with the Mixed Theatre Company from Toronto. And it is a limited registration just to keep the discussion small. We will hopefully have more small discussions because we are limiting that registration. So if you want to register, please do so on our website. We also have two webinars coming up, English and French, on promoting working together, living together in retirement residence or cohabitating in shared spaces. So there's a program that's just been out. It's called the Gift in Residence program. So that will be in November on the 16th and the 23rd. And coming up, we're excited to announce our ethical and legal responsibilities on reporting elder abuse. So we have a number of speakers that will be talking about reporting, what the roles and responsibilities are. We do have someone, I know Melanie kind of alluded to ethics kind of discussions around when people don't agree on decisions. We do have an ethicist, a bioethicist, who will be attending the conference and speaking. So check that out on our website to get to the link, and you can register for the conference. The other conference that we're hosting is near the end of the month in November on gender-based violence, and we are partnering with the Canadian Network for the Prevention of Elder Abuse and Women Act. And this is in recognition of the 16 days of activism against gender-based violence. So we have a great lineup of speakers where you can choose those sessions that you want to attend as well. And all this information will be posted hopefully by the end of day on our website. I believe it might be up already, where you can already start to register for those sessions as well. So again, thank you, everybody. Just that reminder about the evaluations, to fill that in. And if you want to contact us directly about a situation, you can call our main phone number. I have my contact information. You can also find information on our website with lots of resources and information. Any of the resources that we posted today, I will post on the website with the recording as well, so people can have access to those. So on behalf of everyone who attended today and our organization, thank you so much, Melanie, and our ASL interpreters for the great work that you do. And we'll see everybody at the next webinar. Thank you.